As I said, like,
Staying-
it's like, yeah,
They're staying about the introduction.
it's like, it's like, I really don't have a lot of confidence that because there's a preamble to there, it's gonna change people's behavior.
We're now live. We're now live. Oh, it's right.
Put your professional voice on.
Track runs fast, too. Or maybe it's by lunch.
Their invitation is going to January.
Yeah, they lost some dates, they got compressed, so they decided to push it up. When they had the rain and storms so they lost some dates in October, they bumped something down.
There is a change in the financial side of it. Can you still contribute to directly to private utility or
Charleston
Southern
Collegiate.
Collegiate?
Yeah, I thought,
Or is it just going to the employees?
depends on what you do.
So, we
Just-
get Michigan,
If you're a
and then
benefit,
I live here.
they distribute it.
I'd like to call to order the October 5th regular meeting of the Keel Island Planning Commission. Could you call the roll, please, ma'am?
Ms. Peterson,
Here?
Dr. Hollingsheller, Dr. Michael,
He's here.
Is he muted?
Can you hear us?
Mr. Daddy,
Here.
Mr. Kelly,
Here.
Mr. Allen,
Here.
Ms. Gay,
Here.
Ms. Anderson.
Here.
Can Michael hear us?
I don't know.
Is he muted?
I don't
Can you
know.
hear us, Dr. Heidingsfelder?
I don't guess so.
There must be
Send a message to him.
Can you hear us? Can you hear us? He unmuted himself. Oh, wait, he sent a question.
Aye, he raised his hand.
I have no audio from the room yet.
How about the click to join audio button in the bottom left?
I still have no audio.
Oh, there.
Can you hear us now?
Can you hear us? Can you hear us?
Stephanie? The bottom left corner.
Yeah, he's working on this. Can you hear us now? Can you hear me now?
Like that commercial, you know, can you hear us?
Is that a Verizon commercial?
No, he still can't hear us. No, it's not showing us muted on his end.
He may have the wrong audio input on his end.
He still can't hear us. Maybe ask if it's on his end, maybe?
says he can't hear us. I texted.
I'm chatting with him.
His speaker on.
Okay. Is your- Okay.
It worked with me. I could join the call right now. It'll work.
Well, we'll see. He's signing out. He signed out and he's signing back in.
Yeah. See his little mic, you can see the sound.
Why is it still showing? Okay, so he's connecting. Okay.
Yeah.
Okay, you're connected to the audio. Can you hear us now?
I can see you, but cannot hear you.
You can hear us? Maybe he can go through live stream, but he can't. He won't be able to.
I don't know.
Can you hear me?
Yeah, we just got it.
Okay. You can hear us? Can you say something again? Oops. Did you do something here? Do you want to go back? Did you change it? Can you hear us? Nope, he still can't hear us.
Look at
He
the mic.
needs to make sure
Huh?
he's
Oh, yeah, because our mic,
got the right audio
Ours.
coming in
On his end.
okay.
It's his laptop. Or
What can I tell him?
his laptop speaker needs to be on.
Make sure your
Phone.
laptop speaker is
That worked
on.
okay. Yeah.
I think it's on turned on. We tested this out.
I think it's once you mix the audio with the video.
Yeah, you can join by phone.
Right.
too.
He was, I think he joined by phone, but I'll say to him. I asked him, but can you try and join by phone? I asked him.
That's good.
Okay. Our audio is working. Oh, that's just me. I was like, yes, my speaker is on, but I can see for your screen that you are muted.
Oh, well, that's that camera right there. You're muted
Okay.
right now.
Okay. Our computer here is the camera. Okay. It's the camera audio. That's what he's seeing, right?
Yeah.
That is not the computer that we are talking through. It's the camera.
Joanne,
Yeah.
you said you can text Michael?
Yeah.
Can you just ask him to say something?
It's
Like, I'm
not-
here, we'll proceed.
I think we heard him. He can't hear
I
us.
heard him very faintly
Yeah, but
once.
you can totally hear us because look.
Yeah.
Saying, please say something.
And when I'm talking, our mic is working. We have a mic here so we can see that our audio is working fine.
Yeah, I mean, he's,
Can you hear me now?
Yes, we can hear you.
Hello?
We can hear you. Oh, let me type. He can't hear us. We can hear you.
He can't hear us. That's
You cannot hear us. Can you try using your
He said
phone?
that- Stephanie, he just texted me, see picture above, you're muted. Are we muted there?
No, that's not. That's still, I sent him a message saying that that's the camera
Okay. I
audio.
will
It's
try
not
to
the
use my
computer
phone.
audio.
Now we have two audios, one video.
Can I take the roll again?
And he has to unmute.
I asked, he said, he's,
You should stay unmuted.
We have a quorum, don't worry about
oh, he sent me a picture that says council room floor is muted. He sent this picture.
It's not.
Yeah.
Unmute it so that he can see.
Yeah.
Yeah.
It's the camera. I sent him saying it's the camera audio that you see muted and not the computer audio. He's looking at, we're running two separate devices. And so I'm talking, what he should be able to hear out of where I'm talking, not through the camera audio, is what he's looking at. With view through the computer audio. I asked if he can use his phone.
Yeah, if you join by phone, that'd be good.
Okay, great. He's trying his other computer. Are everyone able to hear through live stream? Are they hearing? Okay. Okay, looks like he's coming back. On. Hello? Can you hear us? Hello? Can you hear us? Please proceed. I have no comments to the meeting minutes. Okay. Thank you. If you'd like to proceed, he said he has no comments to, I
I
made,
guess we will move
may just
on and
have to-
hope that the technology catches up with whatever. The next item on our agenda is the approval of minutes from our September 7th meeting. Could I have a motion to approve? And a second? Second. Been moved and seconded. Are there any changes, comments, corrections to the minutes as submitted? Hearing none, all those in favor say aye. Aye. Opposed? Thank you. As is our new standard, we offer visitors the ability to check a box next to their name if they wish to speak in the citizens' comments, public comments. We have no checks, so there are no public comments at this time.
Mr. Chair, we have a person in the audience. He didn't realize he needed to check the box. Mr. Brad Belt, he would like to address.
Okay.
Thank you.
Before calling on Brad Belt, I would note that we received letters from Adam Barr, who's an attorney representing Riverview Homes and Riverview Townhomes. We also received a letter forwarded from Ted Bonney, originated by Perry Mullinoff of the Preserve Kiowa Group. Both of those letters will be entered into the record. Mr. Belt.
Yes, thank you, Mr. Chairman. Brad Belt, 151 Bobcat Lane. I am a homeowner in the Riverview development and appearing on behalf of the Riverview HOA. I would note for the record that I'm joined by the president of the Riverview HOA, John Grierson. I'm also a member of the board of Preserve Kiowa, and I appreciate the entering into the record of the two letters and trust that they've been provided to the Planning Commission, and you've had a chance to review those. There are a few other matters that I think are important to get on the record and or clarify the record with regard to the two pending preliminary subdivision plat applications. The first is to clarify the relevant review period, assuming ultimately that the Planning Commission deems it appropriate to approve the preliminary subdivision plat. It appears that these are being pursued pursuant to the town's subdivision ordinances. And I think, as you all know, it's Section 12-279 under the subdivision ordinances provide for a 3-year approval period followed by a single 6-month review period. And since those provisions or ordinances have been on the books for 17 years and haven't been changed, our assumption is that that's what will be operable here. I know in other contexts it's been suggested that preliminary subdivision plats might constitute a site-specific development plan. Whether or not that's a facts or circumstances matter is not really clear, but it's clear looking at the state statute that that would not be met in this case in any event, because a site-specific development plan pursuant to the state statute has to describe with reasonable certainty the types and density or intensity of uses for a specific property or properties. I would note by virtue of the applicant's own summary brief, it states, while predominantly residential, this strategy provides opportunity to build a recreation amenity center, but also potentially for parcel 13-1 and lot 1 and Kiowa Island Club membership at large. Kiowa Club Support Service might also be incorporated into parcels 9 and 8 and 10, and this might result in the elimination of 10 residential units. No specificity, no certainty there whatsoever, so it clearly cannot be a site-specific development plan. It also cannot constitute a vested right, because a vested right under state statute means that the right to undertake and complete the development of property under the terms and conditions of a site-specific development plan. Indeed, in the materials provided by the planning director to the commission members, there's a caveat that approval of the preliminary plat does not constitute approval of proposed buildings, parking spaces, building heights, or other sites or uses or other design elements. Therefore, the criteria for vested rights are not established. So that just brings us back, I think, to 12-279. So the applicable review period would be 3 years with a potential 6-month extension. I'd then like to shift to issues with regard to the Lot 1 application. And the issue there is you're being presented with a preliminary subdivision plat application, which is a bit disconcerting because there's already been substantial site work done on Lot 1. There have been several acres of clear cutting of trees on Lot 1, which is only supposed to occur subsequent to approval of a final site plan. We're in a bit of a bind here because this, by definition, is a preliminary subdivision plat. We've actually submitted a FOIA request on behalf of Preserve Kiowa to the town with regard to providing a copy of any land disturbance permit allowing clear cutting on Lot 1, and no such document has yet been provided. Whether that means it doesn't exist or not, I simply don't know. But I would further note that it appears to be a direct violation of the terms of the development agreement, particularly Designing with Nature, which states very, very clearly and explicitly that with regard to multifamily home projects, no site clearing may occur without having obtained a Kiowa Island building permit from the ARB, which can only be provided once all of the processes attendant to review of a site are approved. So to the extent that there is a potential violation of the development agreement with regard to the lot clearing that has occurred, the clear cutting that's occurred on Lot 1, that would seem to me would need to be addressed prior to any action being taken with respect to the preliminary subdivision plat, because it may warrant an additional condition being imposed and or mitigation. But again, there has been no final approval of a site plan for Lot 1. Is all that has been provided is site plans for the Cape project, not Lot 1. There is, at least we've requested, not received any indication of a land disturbance permit either from the town or DHEC as would otherwise be required. I won't belabor, shifting now to the Beachwalker parcels, I won't belabor the various issues that we raised therein, because you have the benefit of those materials and they are in the record. I would simply note that we've suggested that if the Planning Commission deems it appropriate to approve the preliminary subdivision plat, hopefully after resolution of outstanding issues with regard to potential violations of the development agreement, that certain conditions be imposed, which the Planning Commission has clear authority to do. I would note, and there is precedent, when the preliminary subdivision plat was approved for Sam Spit, there were a dozen conditions imposed by the Planning Commission. We've suggested several that we would think would be appropriate to ensure that development does occur fully consistent with the terms of the development agreement, designing with nature, and the town's ordinances. The final matter I'd like to introduce into the record is and in fact this is already in the public record, but I think it should be in the record for this particular proceeding, is a March 10, 2022 memorandum from the Kiowa Conservancy to the planning director, who I know could not be here today, that is specifically referencing environmental statement regarding Upper Beachwalker parcels. In that, the Kiowa Conservancy outlines a number of concerns with regard to development of the Beachwalker parcels pertaining both to stormwater management and mitigation, but more importantly to wildlife habitat, the potential threat to the local bobcat population. And they suggest 4 potential conditions that should be imposed in conjunction with any development of the Beachwalker parcels. The first one is leave all areas within parcels 8 and 10 to be left in their natural undeveloped state. The proposal that's before the Planning Commission only does that for one of those parcels. 2, to decrease impervious surface coverage. 3, to place impervious structures further away from stormwater ponds, and they request or recommend that a naturally vegetated buffer of at least 50 feet to adjacent ponds and nearby structures be maintained, and that all stormwater runoff be treated on site and not allowed to be run into the ponds. So I would commend those to your attention as well, and I'd be happy to answer any questions, but other than that, I have no further comments, Mr. Chairman. Thank you.
Thank you for your comments, Mr. Bill. We have no old business to attend to today, so we'll jump to new business, 2 subdivision applications. I would note that John Taylor is not here today, our planning director, due to a death in his family, so that the town administrator, Stephanie Tillerson, will be presenting on behalf of the staff. The first item is the Beachwalker Commons application.
Thank you. Is it okay if I minimize? Yeah, I'm good. I'm just trying to minimize this. There we go. Yes, thank you, Mr. Chair and members of the Planning Commission. I will try to do my best. I am not John Taylor. I'm sure he does a very good job at presenting this, so I'm trying to pitch to help him out here. And as she said, he hated that he could not be here, but he had death in the family. His grandmother is being laid to rest today. He found out Friday, and her funeral is scheduled today, so I understand why he's not here. What I'm going to do is I'm going to present the first preliminary subdivision plat, which is Beachwalker Commons, which we all know is Upper Beachwalker. Part of my presentation, when I'm done, Mr. Chair, I'm not sure how you guys like to proceed, but we do have the applicants here in case you all have any specific questions for them that I cannot answer. So just want to make sure that's clear. So what I'm showing here is just a location, vicinity of what we're referring to as Upper Beachwalker, which is, we're showing parcel 8, 9, 11 in the church parcel. The current zoning of the parcels, as you can see, based in our zoning classification, is parcel 8 has the classification of R2 and C. In parcel 9, 11 in the former church is identified with zoning R3C. Just showing you just a current future land use map to show that the zoning is consistent with our comprehensive plan future land use map. What I'm showing here is that the development entitlements based on our development agreement as well as with our zoning ordinance. So with regards to the parcels, you all know that the former church, which is identified as parcel 11, is not part of the development agreement. So what I was showing you essentially is that parcel 8 has no residential entitlements, 9 and 11, you will see those entitlements, and the church, former church, you will see those entitlements. In terms of, I looked at the requirements in our zoning ordinance just to familiarize myself with the requirements, as I knew I was going to be presenting for you all today. And I just wanted to highlight, which I'm sure you guys are all aware of, the role of staff and the role of the Planning Commission, but I thought it would be a good idea just to incorporate this into the slide, which is today you guys can approve, disapprove, or approve with conditions. Are you guys getting this? Oh, okay. I wasn't sure. I'd like to continue on just to let you all know that when an application is deemed complete and that's submitted to the planning department, so the planning director deems the application complete based on a set of criteria. Once that is deemed complete, then it's presented to the Planning Commission. The Planning Commission then must act on it based on one of those three things: approve, approve with condition, or deny. If it goes unaddressed for more than 60 days, then the application as presented, along with any supplemental materials, is automatically deemed approval. This is small, but what I wanted to show is that within our zoning ordinance for 12A preliminary plat consideration, there are a list of things that staff is looking at to determine if a plat is deemed complete or if there's anything missing. So, for instance, plats at preliminary stage can come to the Planning Commission, and as Mr. Belt had pointed out, it's not uncommon that the planning director could list conditions. And those conditions could be, okay, before you can go for a final, there's things within our table here that you must complete. So we're going to add those conditions so that when it comes back for final, we make sure those conditions are met. Essentially, a lot of the conditions center around infrastructure is what you typically see condition. So I just wanted to share with you, which I'm sure you guys are all aware, the things that we're looking at when we're reviewing preliminary and final plat approval.
No.
Stephanie got a comment over here.
Oh,
No.
well, this is just a presentation phase. Sorry, Brad, it's not Q&A phase, but you're more than welcome to ask afterwards. So what I wanted to just share with you guys again is just some information with regards to each parcel here. So parcel 9, this parcel was, as you can see, it was formerly used as Beachwalker Office Park, and most recently temporary fitness center for Kika. the former church parcel. In 2016, it was rezoned from community support to R3 commercial. Parcel 11 is the undeveloped larger portion of the parcel. And then parcel 8 is the one that backs up to Cougar Point Golf Course. And this parcel, based on the plat that you guys are looking at, they're not proposing any access, vehicular access off of Kiawah Island Parkway. The access would be off of Beachwalker Drive. And we just want to reiterate again that the approval of preliminary plat does not constitute approval of the proposed building, parking space, building heights, et cetera. That is done at the site plan review process, that is done at the staff level. Part of the preliminary site plan is that they have to essentially show the proximity of buildings, apartments, office, commercial. So what you have before you is essentially showing the location of buildings. It has within those buildings what the use is going to be in terms of, it may say office or it may say residential. And I believe it also may have the number of approximate units within each building. But we do have a note on here that, again, this has to go through the site plan review process. So we're showing essentially a generalization. It's probably going to be, you know, this is what they'll probably propose, but it's just to kind of show you a generalization of where the buildings would fit. Planning Commission review for approval. You're looking at the OCRM critical line, verifying that parcel 8 is not landlocked. We're showing a shared easement between parcels 9 and 11. And that's what we're asking the Planning Commission when you're looking at your review process. Those are the things that you're considering. The Planning Department, as I said, have reviewed the application. We do the technical review, and based on our technical review, they've met the conditions. We've only asked for one condition, which is prior to the issuance of a zoning permit and final plat approval, that proposed access easements across parcels and the vehicular access easements granted are essentially recorded. And what I want to go back, I think would be good to show, and we're talking about this just for public purposes. This is parcel 8 and parcel 9. This is the access that we're talking about here, the cross easement access. As you can see up here, they're no longer proposing a vehicular access onto Kiawah Island Parkway. This is the main gate here, so you will not have access behind the gate. They're showing the access onto Beachwalker. And then this will be a private access here between parcel 9 and 11. And they can explain this, but I believe it also has to do with, does it also have to do with fire or as a requirement there? So we're showing the access between these two parcels there. So those are the access points that we're referring to, that we would condition that before a final plat is approved, that these access are, these easements are recorded. So if it comes back, we will have to they will have to show that they've essentially recorded these access agreements. Now, are there any questions for staff?
Any questions for Stephanie?
Yeah, I do.
Yes,
Stephanie,
sir.
Mr. Belt, in his presentation or his comments, gave me the impression that in his review or the review of his constituents, that there are inconsistencies and errors in the application, and then but then your presentation would lead me to believe that there are not, that it is consistent with the regulations of the. So help me out. Are there errors or are there not?
I'm not aware of any inconsistencies with regards to Upper Beachwalker. I think he was referring to some comments regarding Lower Beachwalker, but with regards to Upper Beachwalker, I know he has said that the Conservancy had wanted some conditions, but I'm not sure of any other inconsistencies. In terms of our review, for technical standpoint and what we're looking at for a preliminary plat that I have outlined, there are no inconsistencies with regards to our, to what's required
Okay, then
of the
then
town.
The second question then is that, okay, so then in the where it says that, that the building and design elements are approved in the latter state by the
Correct.
staff.
Correct.
Is that where the issues that Mr. Blatt brought up are supposed to be addressed?
Some of those issues that he brought up, I believe he's asked for you all to add as conditions, but you cannot add, essentially cannot add new standards. So you can't add things in terms of conditions for this preliminary plat process because it's not part.
Because the development agreement gives him
You want to
rights.
say something?
Yeah.
Yeah. If,
The
go ahead.
site plan review will address building standards.
Yes. Yeah.
I'm sorry, say again?
Site plan review
Okay, so
The
process.
site plan review will address the building standards.
And that's at the
Such as
staff
height.
level.
Okay, okay.
Height.
Number of
And the
units.
design with, for, you know, design with nature and all the things.
No,
that-
that's the
Or
ARB.
B. If they're,
Okay, so there's some things that he mentioned are not, are somebody else's purview.
Correct.
Okay.
correct. Yeah, but setbacks, building heights, all of those things are and will be reviewed during the site plan review process. That's not the preliminary plat process.
Okay, thank you.
Joanne?
Yeah, first, some of my comments, Mr. Belt, you know, great minds, I guess. I wanted to first clarify what rule we're approving this under. Is 12279 the correct ordinance so that we avoid any future problems like we've had in the
It's
past?
under, I'll turn to the attorney, I don't know the code. It's under the subdivision, is that 12?
It starts at 12,279.
So
Nine.
12279, so we're approving this for a 3-year with a potential 6-month extension. So we all are in agreement on that. I want to make
Well-
sure we're talking
Yeah.
about the same thing.
No. Yeah. Is that something different?
That is something that we will look at and
it-
determine if it is applicable or if the state law is applicable.
Well, we can't approve, I don't think, till we know. I would say, you know, if we're going to approve something, I just want to understand under what law we're approving it. I don't want to issue an approval and then have them say, wait, it's not 279, it's this or it's
But
that.
you're just talking about how long the approval is going to vest for
But that's significant.
but it's not significant today.
I
Today-
think it's significant for me to approve something, and I have no trouble approving. They have rights to develop. But I think we have to, all of us, understand under what law we're approving something. I think that's our job.
Let me be clear again and reiterate what Stephanie had to say. Today is a preliminary site plan approval. The goal of this procedure is to create for the town to approve the plat that is going to be filed by the developer. And nothing more and nothing less. That plat has to have easements on it and eventually infrastructure. But it's not to determine standards for the buildings.
I'm not looking at standards for the building.
The question that's been raised, he's raised it, I'll have to look at it. It's a fact-based question that is not a lot of clarity in our state law, which he's referring to. Our past attorney has, there are opinions on that in different contexts. And we'll just have to look at it. But I'm not prepared, and staff isn't prepared today, to offer an opinion on how long that's going to last. But I don't feel like that is a relevant factor in determining whether or not the plat is suitable for recording, which is what this process is about.
Joe?
I have to ask Mr. Chairman, if we
Yes, ma'am.
are approving something I brought, and I've been poring over our land use regulations to understand the rules under which we operate. And I want to make sure that we are following our own rules. These are the rules we've been given of the town ordinances. And I think it totally reasonable to say, we are approving this, and I'm not saying, fine, approve it, whatever, but we have to say, is it under a state law? Is it under this? To say, well, it's ambiguous, we don't know. That's how we ran into problems on Captain Sam Spit, because deadlines and things weren't specific. So I want it to be very specific of what we're approving, what the term of the approval is for, and what the renewal qualifications are. Otherwise, we can't do it.
That term is not on the plat.
Joe.
Full stop.
And it's not,
And
and it's
I
not
mean,
required.
It's not required to be determined today. It is nothing on the plat that says whether it's 2 years or 3 years or no vested rights at all. And so that's my response.
And I would just like to kind of bring it back and just say, when you're referring to what is it the Planning Commission is approving today, the table is 12C1 that you probably saw. On that, those are the requirements that the Planning Commission looks at to approve. You don't go beyond those requirements and say we want to pull in all different town ordinances, because it may not be under purview of the Planning Commission. I understand what you're saying with regards to the timeline, but that's not how our ordinance is set up in preliminary plat approval. When you're looking at the table, that's not one of the things under 12C1 that you would consider. Yes, Mr.
Stephanie,
Campelli.
Really, for comment for Joe as well, I totally agree that the issue raised by our associate here is irrelevant today. But is it fair to say, and it's up to you and council, is it fair to say within the next 3 to 5 years we'll resolve the question as to the interpretation of the state law versus the town law?
I will let the town attorney address that.
Yes, we will be looking at that. We've had a pretty busy agenda. Again, the state law, I will say this, a site-specific development plan is defined under state law, lists several procedures that are included as a site-specific development plan. And I believe it specifically lists a preliminary plat review there. So that's part of the problem, because it does have that. In the case of a preliminary plat review such as this one, where there is not, at this point, density in it, that does cast some ambiguity on it. And, perhaps we will, we can write the Attorney General and ask for his opinion. Someone can seek judicial guidance on it. But the fact of the matter is you will not find any cases interpreting that term. You only have what's based on the statute. And I hesitate to, there may be a site plan, preliminary site plan review that falls outside of the state law, arguably. But there's no definitive answer on that. So I can't say that time and time again, but generally the state law says a site plan review has to be of the density and use to be a site plan review, a site development plan review. But it also says a preliminary site plan falls under a site plan development review. So it's contradictory.
So how long
And
does
that's
the
not part
state
of
statute, so if we approve this, just tell me what law we're following, so I can understand. We're going to go by the state law, fine, just tell
That
us.
determination hasn't been made, and it's not going to be included here, and frankly, I don't think it's gonna matter, because this is going to be recorded. This isn't even the final site plan, so it's not something I can answer today.
So you're saying it's a step in the process?
It is a step in the process. And if, it doesn't even become relevant until 2 years from now.
And what happens in 2
And
years?
then, and they could do, and presumably there'll be a final plat, or, I mean,
So where's the 2 years coming from?
from state law.
That's what I'm asking. So you're saying there is a 2-year time in the state law. That's all I'm asking is what law and what time frame. So you're saying there's a 2-year time
I
frame?
am saying that it's not clear whether the state law preempts this, our ordinance that gives 3 years. I'm not sure why that, I mean,
Well, I think the applicant would want clarity too.
If they submit this for in a year, then this is all.
yeah, I mean, that's the point I'm trying to make.
If they submit
If
in a
they
year.
submit anything within 2 years, there's no distinction.
Right. There's no
It's
distinction.
in time regardless of the interpretation.
If they can submit in 6 months.
And if they don't?
If they submit a building permit between 2 and 3 years from now, we will have to address that. But that probably, again, will not be relevant, because by that point, there will be a final plat review, which will restart that clock in any case, and may well include density. And, I mean, 'cause, see, you're asking me to have a crystal ball here. But, so there are a lot of moving parts. And I don't know what the final site plan application will look like, but I strongly suspect there will be another step to this process before that 2 years runs out and this issue becomes anything of relevance.
Final site plan, or their site plan is gonna.
Any more questions for
I have a
Stephanie?
question. I'm not sure if this is more for Stephanie or for, perhaps for Mr. Kumar. So this plan looks considerably different than what was proposed or what was presented to the community 6 months ago when the various lots were
They have,
to
right.
be one,
They-
and the buildings were all moved around.
Correct.
What has happened to that plan? Is
So
it
that
going at
was,
the wayside?
well, at this time it has, because that plan was referring to collapse, I'm sorry for putting that in your eyes. That plan was proposing collapsing lot lines, and it was also, would require amendment to the development agreement. So yes, the plan that they had proposed that showed no lot lines, essentially one parcel, that plan has been shelved. They're not pursuing to have the development agreement to be amended, because they were going to also wanted to bring in the church parcel, if you recall.
Yes.
So because they're not doing any of that, this is going to be developed as separate parcels, and that's why they're going to have the easement between 8 and 9. So these are now just being developed as all separate parcels.
Okay, thank you.
You're welcome.
Joanne?
Yes.
So this is just a conceptual, not the final thing that'll come to us could be very different from that.
The final that would come to the town staff will not be very different. Essentially, it's going to be this same configuration. What may be slightly different when it comes to the staff for site plan review processes, say, for instance, this building right here may be shifted slightly over a little bit. You know, this building could be shifted.
Looks like there's an incursion into the setback.
Well, within the development agreement here, they're allowed about a 20% variance that the staff can approve. So this will probably be fine. They may decide to pull it out, but based on the agreement, they're allowed a 20% And we believe that that would be fine. So that area that you're referring to, we would know more once we do the site plan review process to really dig into it, but just on the surface, it looks like that they would not be in violation of our, of the development agreement, so.
Stephanie,
But
perhaps
staff
I-
will be looking at that. That's part of the staff's site plan review process.
Perhaps I misheard you, but the final plat does come before the planning
That's
commission for
correct.
approval.
That's
And
correct.
at that time, everything is fixed.
The easement and all of that should be recorded. That's
Correct.
correct. The site
Correct.
plan will not.
Right, we cannot.
Right, yeah, but.
We cannot approve the final plat without that
Right,
being.
because the final plan has to be recorded. That's correct.
Okay. Any other questions or comments?
We can let the developer speak?
Yeah.
Does the developer like to speak?
Are you good, or you want to say something, Mark? Are you good? You just want to offer a few?
Mark, you don't have to.
Okay, thank you.
You're fine, okay.
So
Yes,
Yes,
Joanne?
ma'am.
so this can be approved with conditions, because the things that Stephanie mentioned before were requirements. That was a list of requirements. So if we want to add conditions, like one of my things that I looked at is I didn't see any stormwater management, for example. So we can say we're going to approve it, but you have to have a stormwater management plan.
I think that's beyond our scope right here.
Yeah.
We don't see anything about stormwater management.
But didn't you guys put a bunch of conditions on Sam Spit when you approved that preliminary plat?
The
They were like
conditions
it
but
does-
didn't include those.
No, but it included other things.
Well, that was the whole list that we had. It was on the screen.
Weren't they requirements, not conditions?
Those are conditions that will be on the plat.
So one of the things is that staff has a condition that we would like to add on here. Any condition that goes beyond what is allowed in a preliminary plat, I think you're going into maybe some of the site plan concerns, and that's not a condition. You cannot add new conditions beyond what is allowed for a preliminary plat approval.
Can you say you want the final plat to be consistent with all setbacks, the vegetation buffer requirements, the number of parking spaces? I mean, I think
Not
those would be things we want to be on the final plan. It says we can approve with conditions. Are those conditions that we can put on it? And I don't think they'd object to it, because I hope they're doing it anyway, but I think it's important to get it on the record.
Okay, the conditional plat approval by our own ordinances is pretty clear what that is for. It's not to start adding additional standards or creating new standards. 12-283A states the purpose and intent of the conditional plat approval procedures allows an applicant the right to install infrastructure, sell or otherwise transfer lots, receive zoning and building permits, but not to receive certificates of occupancy. So the conditions are for the installation of infrastructure. That's what we're talking about here, such as streets, which was the issue in Captain Sam Spit, or other standards that are relevant to the infrastructure and the things that we are approving and looking at today.
And this would be the easement in this
The
case.
easement in this case.
So we can assume, and I hate assuming things, that all of the roads and everything they're doing is going to comply with all of the required setbacks and the vegetation buffers that are in the development agreement.
Your approval today is not waiving any standards that they have to comply with.
So the roads, because it was hard to see on the church parcel that there is enough setback. I couldn't tell how wide that is, and I walked the property, but I still couldn't tell.
Yeah, once
where
that,
is.
yeah, and when that goes before the staff, we'll look at setbacks and make sure that the setbacks are met and buffer requirements are met. That's part of the staff review process, that's part of the site plan review process.
If,
Can I say something?
Oh, yes. Dr. Michael?
Thank you. So, Stephanie, you were talking a lot about, what the staff has looked at and the requirements, and I think we all understand, the setbacks and the development agreement, et cetera. But I would also assume that the staff looks at our, objective of designing by nature that I think we all committed to. So how have you or the planning commission, the planning department staff looked at the designing with nature standards?
So the design with nature standards, as you know, is not a town ordinance, it's an ARB private, so we cannot, sorry,
But it is.
So
But I
we
think
can't.
isn't
So are
it
you
also
asking if we're
part-
enforcing it, or are you just asking if we just make sure that we're kind of
No, I'm not talking
making,
about
because we don't have,
enforcing. I'm talking about, looking at a proposal that comes from a developer. And of course, I fully understand, you look at the development agreement, you look at the zoning requirements, the setbacks and everything, but aren't you also looking at it, how that proposed development actually just fits with, the neighborhood, fits with, the tree levels, fits with what I think we all have agreed upon in various ways, both as the town and Kika. So how does that, flows into your process?
so within our process, our ordinance is really just, we don't have, I think some of the things that you're referring to that may be found in ARB's requirements. So when we're looking at our process, we're looking at, again, buffer, setbacks, we have building heights, parking, we're not even signing anything that's ARB. We don't have a tree ordinance, so we rely on ARB for that standpoint. So when you're talking about kind of the scale and mass and how it fits within the community, within our comprehensive plan or anything within our ordinance, we're definitely applying it, we're definitely enforcing it. Some of the other aspects that you may be referring to is not within the town, it's within ARB. And what I can say is that, being here on the island, of course, you guys know, I've been here on the island for 7 years, and between the town and the ARB regulations and what the resort has done and what they've done with other future projects, I think that we all work together and we've created a great environment, a great reason why you all are move here. So I don't see that changing. I see that relationship still continuing in terms of what we have to review from the town's perspective, and then with ARB reviews from their perspective. But I understand what you're saying, and yes, we will do everything within our regulations that we can to make sure that they meet those requirements. And I'm sure the ARB would do the same with regards to their requirements. So.
Okay, then okay, I understand that. So second question in that context. So we all have our comprehensive plan as a town of Kiowa that we all agreed upon. It's up for review in a year or two, but currently we have a comprehensive plan. So when you as planning department staff and John as the leader, look at a proposal like this, how at the moment would you judge that this proposal and the other one we are discussing today fit with the comprehensive plan?
Well, from the comprehensive plan, it's just looking at essentially the land uses, and it is compatible with our comprehensive plan. Well, like you said, we are looking to kick off a more robust comprehensive plan that would be more, it could be more in tune of looking at neighborhoods and creating neighborhood plans and creating more of that look and feel, I think, that you're referring to. And then ultimately, whatever is adopted there, then you look at pulling it into your zoning ordinance. So then your comprehensive plan could then be the catalyst of what you're saying. And so if there's things that you all believe that the town should do in terms of beefing up their regulation or design standards, we will be able to incorporate those at that time and make it so that the town does have a little bit more teeth to be able to look at things beyond just setbacks and buffer yards and building heights and parking standards. As I said, we don't even have a sign ordinance, so that's one of the things that maybe we want to be able to incorporate.
Okay, but our current comprehensive plan, there is no mismatch between, you know, what we have stated in the current comprehensive plan and what the developer is proposing at the moment.
That's correct.
There's no.
That's
okay.
correct.
Okay.
In
Then
terms of
my-
uses.
Okay, understood. Then my third and last comment or question is traffic. I think we have seen a lot of concerns that comes from the community when it comes to traffic. I think we all kind of a little wiggly about, you know, how after timber now also the Cape will influence this. Here we are talking again about a lot of dwelling units. So how would the staff assess the traffic impact of such development and the two developments actually we're discussing here today?
We've worked with Kimberly Horn. We have a comprehensive traffic study that was done. It's available on our website for everyone to view. And with regards to the impact and flow of the residential areas, what they're saying is that there's a minimum, they say minimal impact. The impact that we'll probably see, I would say, as the town continues to develop and mature, is the impact on Beachwalker County Park, which the town is, we've added the right turn lane to try to help with traffic there. We've added the queuing system. We're looking at the intersection of Beachwalker and the Kiawah Island Parkway. We're trying to work with the community association because we believe that, you know, the pass office at where it's currently located could be problematic. So we're still continuing looking at other options that we can do and that council can possibly implement. Of course, it's dollars and cents, but we are looking at those things. And we have had a number of traffic studies that are completed, and we still have a few that's ongoing with regard to the intersection. So it is, we're constantly talking about that through our public safety committee, through council meetings, planning commission, so yes. But as of right now, from a site plan review process, there would be nothing in our ordinance that would prohibit us from denying, if it meets all the conditions, to deny the application because of the traffic. But based on the study that's been done by Kimberly Horn, those two projects are not creating a lot of traffic. It's just the intersection itself and probably at the end of Beachwalker County Park that will be drawing the traffic. But yes, we are always looking at traffic.
Okay. Now, I looked at this traffic study, and please correct me if I'm wrong. I was not 100% certain if they really looked at these different projects alone or in combination of them all together. You know, I mean,
they looked
these
at it in
two,
combination.
And Timbers and Cape and Andal West, etc. I was not left with the impression that they really look at this as, you know, as a comprehensive situation of traffic developing with all these new dwelling units. But please correct me if I'm mistaken.
It was very comprehensive. They did look at all the projects, and actually with Upper Beachwalker and Lower Beachwalker, the assumptions that we gave them early on was a little bit more than what's actually being proposed today. So they're aware of the agreement with KICA and the partners. So when they did their assumption, they put all of that in the mix with regards to Timbers, the Cape, the agreement with KICA, the Lower Beachwalker, the Upper Beachwalker projects. And so they kind of, again, pull that all together and came up with what they thought needed to be done with that intersection. And also part of this is that, as they said in their proposal, a lot of the improvements to that intersection really will be more effective if we can do something with the pass office. They are also working with the community association. They looked at Kiawah Beach, I believe that's the Kiawah Beach Drive. So we're taking this all, it's just not happening just kind of independent of projects. We're looking at, they being Kimberly Horn, worked with the community association and working with the town, so they're doing a very, very comprehensive traffic study analysis for us both entities.
Thank you.
You're welcome.
Thank you, Michael. Joanne?
Yeah, I just wanted to follow up on something Michael talked about, which I wanted to.
I'm sorry, something
concerned
who
about
talked
as
about?
well, the designing with nature. You talk about the ARB. Well,
Correct.
the whole ARB guidelines are incorporated into the development
That's
agreement.
correct.
They're part and parcel of the development agreement. Therefore, the town does have oversight because it's up to the town to be sure the development agreement is enforced.
And remember, the development agreement, and Joe helped me with this, but I believe the development agreement also states that the town essentially gives back to the ARB, but I'll let you
The only
articulate
reference
that.
in the development agreement to the ARB is that the ARB has the exclusive jurisdiction over the enforcement of the designing with nature guidelines. So that's the only, it does not grant the town authority. It makes clear that the town does not have authority to enforce guidelines that are created pursuant to a private contract between the owners of property and KICA, or the association.
Yeah, Kika.
And that is not a governmental function to enforce private agreements. So not only is it, I mean, if that language wasn't in the development agreement, the town wouldn't have a role. But that language is in the development agreement and specifically confirms the law that already exists and states that the town, that the ARB has exclusive jurisdiction over the interpretation and enforcement of those guidelines.
And the guidelines are very specific, okay? It outlines very specifically. For example, a tree survey has to be done before any clearing of the lot happens. That's very specific
For the ARB.
in the ARB guidelines, which are incorporated into the development agreement. So I'm assuming whoever signed the development agreement on both sides agreed that this was part of the development agreement.
It's referenced in the development agreement, which again states that ARB has exclusive jurisdiction to enforce and interpret those designing with nature guidelines.
So you're
Full
saying they
stop.
can say, no, you don't have to do the tree survey, you don't have to do any of this stuff.
I'm not saying anything of the sort. I'm saying it is outside of the town's jurisdiction and certainly outside of the jurisdiction of the Planning Commission during this site plan review,
Not site plan review,
preliminary plat review.
I guess I
if I
just
might-
want to be sure that all agreements are followed.
Well, the town can't force KICA,
ARB.
It's,
I mean
Kika has nothing to do
ARB,
with it.
to enforce
They're-
their own rules.
Just like they can't.
That's between the ARB and the property owners. That is a private contract.
Like they can't enforce, like they cannot enforce the town to enforce our
Yeah.
own rules.
That's a good point. Just like ARB can't force the town to enforce our rules or interpret our rules.
Let me try to cut this, not short, but try to cut it to a more understandable position. A layman looking at this would read it to say, and not a legal decision, would look at to say, okay, the ARB is out there, they have standards, the applicant has to go to the ARB first, get permission. When it comes to the town for building permits, the town's responsibility is to make sure that the ARB has passed on it, satisfied its conditions, and given approval to the applicant to go and get his permits. That's our responsibility in the town. You may disagree with it,
No,
Steph,
that's
but
a
that's
good-
basically the responsibility. The planning commission is not in that process at all.
Mr. Chairman, one wonderful fruitful discussion, but I think it's time to call for,
Why don't we have a
Question?
motion made to accept this application with the additional condition of the, as suggested by staff, and they just took it away, of course. Prior to the issuance of zoning permits and final plat approval, proposed access easements across parcels and the vehicular access easement granting access to parcel 2070500-120 across 207050004 via Beachwalker Drive shall be formally recorded with the Register of Deeds. If I could have a motion to that effect.
I move that, okay, and I second it.
It's been moved and seconded. Are there any other comments before we have a vote?
Sorry. Yeah,
Okay,
we
Joanne.
haven't talked about the easements at all yet. This is just a roadway easement.
This,
It's shown on the,
Yeah, you know, because I looked at the, there's no vehicular access on Key Island Parkway. There was none before.
but they had the right until they abandoned it with this plat.
It wasn't in the development agreement anymore.
No, yes, it is.
Is
I'm
it? I
sorry,
looked
yeah,
through
they
it.
have access,
They
so
front on a street, they have access.
they have, yes, they have
And so they're
access.
abandoning that, and in order to do that, they need to have an easement across from one lot to the other.
I have no trouble with the easement. I read it differently that.
They have, currently
Key Island
have,
Parkway, but I'll
You
leave
know,
that for
there
now.
was also a preliminary discussion about this whole area. Somebody said 6 months ago, at least 6 months ago. It was circulated in one form. Comments were received from the public, comments were received from the staff. It revised the plan. This is the result. We're being asked to consider a preliminary plat based on all the comments. Whether we agree with the solution, time will tell when they get the permit stage and when they go through the ARB. But at this point, we're considering something that's gone through and solicitation of views from the entire island, not one section of it. Unlike, say, Riverview, for example, I don't think there was any discussion with the rest of the island about Riverview. People people down the street, let's say, were very unhappy with the potential. There were a number of discussions with that area, but it was not felt that development needed to go out to the entire world for permission. That development was brought to the commission. It met all the requirements. It was passed through the ARB, got its permit, and was built. And I'd be the first one to say it turned out very nice. And basically, people expected and understood that the rules would be followed, development would be completed, consistent with what the town has done for 25 years. And there is no issue with Riverview. I mean, you can make a whole bunch of issues with Riverview and say, oh, it's different than this. Well, yeah, it is. But yes, it's very similar too. It's got houses, it's got condos, it's got height, it's got open space, it's got a lot of things. But on the other hand, it is consistent with the ordinance, it's consistent with the ARB, and the permits were granted, and it was built, and I don't think anybody's complained since then about what the Riverview community looks like.
Mr.
And why
Chairman,
it's
we've got,
consistent or
Matt,
inconsistent.
we got a
Andy, you're off the-
motion,
track.
we got a motion and a second.
We have a motion and a second. If there are no other comments, I would ask for a vote. All those in favor of the motion, please say aye.
Aye.
Aye. Opposed, say nay.
Abstain. And my reason for, I'm abstaining just because I'm not comfortable approving something that we don't have an ordinance that we're under. I have no problem with.
I'm sorry,
the
what-
plan.
And Madeline, did I
sorry.
hear your vote?
I'm sorry, what was the motion,
okay.
please? What was the motion, please?
The motion was to accept the application with the addition of the condition of approval written by the staff that is in the supporting
Okay.
documentation.
And Mr. Chairman, you were planning to ask me for my opinion as well, or?
Well, yes, when I called for a vote, I expected everyone to vote. So do you have a vote?
I have a vote, and I say no.
Very good.
This is not how this island should develop. When anybody looks at the Cape, and I have very little sympathy for people
Dr.
saying
Michael,
that this turned out nice.
You're
So
out of
we
order
don't
right now,
want-
sir.
We don't want a second Cape on this island, so I clearly say nay.
Okay, the next item on the agenda is the preliminary subdivision plat for Beachwalker East, parcel 13, lot 1. Stephanie?
Yes. Thank you, Chair and members of the Planning Commission. I have a drawing up there to show you. This is for parcel 13, lot 1, and it's this particular lot here that I have highlighted in green that we're discussing right now. The current zoning of parcel 13, lot 1, as I'm showing right there, is R3C. And then I'm just showing, again, the current land use map that's reflected. We're going the right direction. And what I just wanted to show is just remind everyone, or for those that are not aware, in regards to the KICA KRA agreement, is for the areas that's highlighted in green here. So this is parcel 13 here. And so as you can see, it's a portion of parcel 13 and all of 13A. And then this is, of course, timbers next to it and dune side there. So the agreement limits to no more than 120 residential dwelling units and related amenities within 13A, within 13A here and a portion of 13B. So this is 13B. And then no more than 4 residential buildings for parcel 13B within the green area. And that's the agreement they have currently right now. That's recorded with the community association. I just wanted to highlight the development agreement entitlements for you there. So you can see that they're entitled up to 100 dwelling units, and then we're showing you in terms of the different types of up to 10 multifamily residential buildings, and then we were just showing you how that breaks down. And then also just reminding again with regards to the access restriction that is in place with KICA and KRA onto Southern Pines Lane for parcel 13, lot 1, and then the remaining part of that development would dump out on Beachwalker Drive. And then again, as part of the preliminary plat requirement, they need to be able to identify and locate multifamily commercial office buildings here, and so they are doing that. And as you can see, they are still meeting the requirement that they have with the community association, and then they're showing you the placement of the remaining other buildings. And part of this, again, is we're looking at any type of easements or other agreements that they may have. So I just want to go in and just say that staff reviewed this preliminary plat, and it meets all the conditions in terms of what we have to look at for the technical review, and we do not have any conditions for this particular plat. It's consistent with our regulations and requirements. And again, we just wanted to remind the Planning Commission that when it's time to go through the site plan review process for the building height, setback, buffer requirements, all of that will be done at the staff level during the site plan review process. Any comments or questions of staff?
Thank you, Stephanie. Questions of Madeline?
Yes, Ms.
So,
Okay.
so really, this is the only piece of the process where we have a say. And from this point forward, all decisions with respect to height, et cetera, will be a staffing decision?
Well, it will come back to you for final plat approval, but once we actually start getting into the process of looking at setbacks and buffers, that is a staff level approval, so that will take place at the planning department level. That's not, a planning commission doesn't get involved with the site plan review process, so that's correct. It will come back for final plat, and that is a process that has to be reviewed and approved by the Planning Commission.
Fred,
Yes, Madeline.
this is where I have the concerns about the the clear cutting that happened at Kate. Now, is this an appropriate time for me to talk about that?
You can, it's been talked about, but we'd be glad to hear your thoughts on it. As Stephanie has said, that is between the ARB and enforcing their guidelines and the developer who cut down the trees.
Is there input that we can have on that piece of the development?
I don't believe so.
Already done.
Joanne?
Yeah, same original question, which
Yes.
I'll leave it, which code we're under, because I do think it's important that we approve under a regulation. I've walked this, I've gone down and looked at it, I assume or hope that all of you have as well. There is a huge part of it that has been clear cut. And I have a hard time when you say, well, that's between the ARB and the developer. Well, the ARB works for the developer. The town, I think, has the responsibility to enforce the development agreement to make sure the rules are followed. And I think that's been a disconnect, and where there have been a lot of objections on the part of the community that, how did this happen? How did that get clear cut? Well, there have been no approvals yet on parcel 13 lot 1. And I see the chair of the ARB is here, and I would really appreciate hearing, you know, where's the tree survey? Who approved clear cutting that parcel prior to, by your own rules, before they cut? They're supposed to do this, this, and this. And I haven't seen that any of that has happened. They cut and they didn't follow your rules. Can somebody address that, please?
I'm not sure that's, well, what you're asking is not a preliminary plat question. So in terms of what staff or the planning commission is required to approve. So with regards to our development agreement, there are things in there that the town is required to enforce, and we do the things that we have to enforce. We do review that during the site plan review process. But I understand, I hear you're asking about, I think, a project or something that was done that was allowed by the ARB, but
was it allowed by the ARB? That's a question. I don't know, was it?
But I think and if they want to answer, they can, but what we're here to do today wasn't really, that's not part of the Planning Commission's process in terms of looking and approving this preliminary plat. So you're incorporating, so essentially, I think what possibly is happening, and I'm sure we may have a disagreement on that, but you're incorporating a process into the discussion that is not part of the preliminary plat review process. So you're asking for an answer.
Joanne, with all due respect, I think, that's a question that should be at the KICA board meeting and to ARB. It's
Right.
not, it's not something, we would be off the reservation if we tried to take on issues that are not we don't have the authority to take on.
Is the development agreements outside our purview? Because the development agreement's between the town and the owners.
That's correct.
And my concern in approving a plat that there has been what we think, and I don't know because I haven't seen any background from the ARB.
But the town attorney clearly says that the town signed over the policing of that to the ARB. We got an agreement and we turned it over to the ARB. I understand your concerns. I have empathy. I am in agreement with a lot of your concerns, but it's not our issue.
So who should
Go to
fine
the
the
go to the
town?
KICA and the ARB. That's where it needs to be.
I
Well,
think it's the town and the ARB.
I
not
think,
Keith.
I think we are maybe
she's
looking at
referring
this a little bit, I think we might, I understand all these procedural topics, but at the end of the story, the planning commission, the way I see it, is the only oversight for the community that a development goes in the right direction, okay? And I understood our role, beside all the procedural issues that, Stephanie very well explained, but we still have a responsibility for this community.
So Michael, I had a training session this past month from the board. It was on form-based codes, And what you're you're all talking about is, and let me ask, that's storm-based, that form-based codes, what they want to do. But we do Euclidean codes. We work in geometry. And we don't, and if we could change to form-based, that's something we could, we can modify our codes and go to form-based, then you talk about the look of then we would have responsibility for how a neighborhood develops and what amenities and things that are approved in there.
And yeah, the Planning Commission has many opportunities to address some of these issues. If the town wants to create its own tree standards, that ordinance, if it's in the zoning code, which probably would be, will come through the Planning Commission. And that would be an appropriate time to discuss it. If the town wants to change height standards for buildings, that is a change to the zoning code that will go through the Planning Commission. We are preparing to update our comprehensive plan. The Planning Commission has an enormous role in that process to address future development and the direction of that future development. Today is not one of those days. Today is a preliminary plat approval of some easements and road access. And that's all it involves. It does not approve anything else. It does not waive anything else. All it means is the town is in agreement that the plats submitted and the easements that appear on those plats are in keeping with the current standards. That's it. So I just want to make that clear. Planning Commission has many opportunities to address these issues, but that day is not today.
Well, I understand your point. Then I would like to file a motion that we table both proposals until we have completed our new comprehensive plan as a responsibility of the Planning Commission.
Michael, we've already
And
approved,
then-
Michael, we've already approved the first application.
Well, then I do it with this one. I don't care. Then hereby I put the motion down that we are
can I just-
tabling this. I'm sorry. I was putting a motion into motion, so to speak. So I would like to propose as a motion to the Planning Commission that we are tabling the current preliminary plat approval that has been put forward by the developer until we have completed our new comprehensive plan that hopefully will incorporate the concerns of the community and actually also the neighbors. We haven't even talked about the neighboring properties yet, as they have put forward in recent days their concerns about both plats actually. But then I would like to put that motion to vote that we are tabling this preliminary plat until we have a new comprehensive plan that can incorporate all of these things that I think rightfully Mr. Wilson put in front of us.
Doug?
Is there a second for Michael's motion?
I'll second it.
Thank you. Mr. Chair, can I just ask a quick question for
Yes, ma'am.
Michael? So as I was showing with regards to our preliminary plat approval process, if the Planning Commission fails to act on this within 60 days, it deems as an automatic approval. What you have to do is get a mutual agreement with the applicant if they're willing to extend it. So as part of your motion, are you asking the applicant, are they going to be willing to extend it? Because if you decide to take no action on this, after 60 days, it would automatically approve. That's per our ordinance. I just wanted clarification
Michael,
on that.
I think she has a point there that it's probably best to withdraw that motion because of that. What I'd like to ask that maybe we can do, and I come back to this from the others, the ordinances
Wait, let's deal
say-
with Michael's motion first.
Okay,
Has it been
I'm
seconded?
commenting on Michael's motion. It's a motion and seconded. Can we do instead approve with conditions?
You can, I guess we'll go back to the first application. The staff doesn't have any conditions, so I'm not sure what conditions you may want to add on here that would not create new standards. Because you can't, as we said in the first application, you can't create conditions that will essentially create new requirements that's not in our ordinance. So are you asking, can you create something that falls within our ordinance? Sure. It depends on what you're asking. I'm not, what conditions you made that. But you have a motion and a second, so.
Any other comments on the motion to?
Okay, so then I would hereby like to withdraw my motion because I don't want to give the developer the automatic right as Stephanie just described.
Thank you. Madeline, do you concur?
That's fine.
Thank you very much. I guess we're ready for a motion on the preliminary subdivision plat of Beachwalker East, parcel 13, lot 1. If I could have a motion to approve and a second. Any further comments on this motion and second? I'll call for a vote then. All those in favor say aye. Aye. Opposed? Nay?
Nay.
Mike? Nay? Is that a nay, Michael?
That's a clear nay. I think this is not in the best interest of our community.
And you're voting no also, Joanne? Okay, thank you very much. And you're abstaining, Madeline, okay. Then there are 4 ayes, 2 nays, and 1 abstention, so it is approved. Next item on the agenda is item 7, correspondence staff comments. Stephanie, do you have anything for us?
No, just as a reminder, Andal West, Brad, is that Monday? Is it 11th? You know, 10th is Monday? Is it Monday? It's Monday. So I encourage anyone from the community, please go out to town. We have sent out some information on that via our e-blast. I'm sure we'll include it again tomorrow on the e-blast, so I'm sorry I don't have the time, but I know it's Monday, so I just wanted to remind everyone about that. And that's all that I have, now unless you have any questions for me.
Okay. I see our council liaison has left us. Okay. Thank you, Petra. Any comments from the public? Item 9.
Oh, comments from the public?
Yeah, public comments.
Yeah,
We have
I'm
2
sorry,
sections.
I think want to speak, I was closing stuff down.
Again, Brad Belt, 151 Riverview. Color me not surprised about with regard to the decision that's been made. What is disconcerting, and I know this is moot with regard to the current approval, is the clear, in my view, with all due respect to council and town administrator, misreading of the town's ordinances and the development agreement. And this is really more for the benefit of anybody who's watching. And I know there are people doing that because we keep getting text about it. This is an issue that has to be resolved. The town has not granted unfettered discretion to the ARB, which is the developer, one and the same. And Joe, I will read the language from the development agreement, which says, first, except as otherwise provided herein, and we'll get to that in a minute, the ARB shall have sole and exclusive jurisdiction with regard to the standards and guidelines set forth. And as a former head of a regulatory agency, I can tell you, and I suspect you would have to agree, that jurisdiction does not equate with discretion, and certainly not broad interpretive authority. And I go back to the first sentence, which says, except as otherwise provided herein. And if you go directly above the provision, is just one example, and there are many in the development agreement. It says the tree replacement guidelines as promulgated by the ARB shall continue to be applied, and they can only be changed with approval of the town. That does not mean that the ARB has complete and exclusive jurisdiction and discretion and executive authority. And it's the town's continued insistence that that is the case, which is the root of a lot of the problem here. And to continue to suggest that the town can't enforce what they're saying is a private agreement is simply wrong. The town is a party to the development agreement. They entered into that development agreement with the developer, with Kiowa Resort Associates, Kiowa Partners. ARB and the developer are one and the same. Just as the town has the right and indeed the authority and obligation to enforce the terms of the development agreement to the benefit of the public interest vis-a-vis the developer, they have that same right, authority, and obligation vis-a-vis the ARB. It's the town's requirement statutorily under state statute to annually review and determine compliance, ascertain that there has been compliance with the development agreement. There's a state statute requirement, and it's embedded in the development agreement as well, for the developer to demonstrate that it has complied with the development agreement. We've requested, through a FOIA request, to get a copy of the demonstration, whatever form and manner that is, from the developer that they have complied. That has not been forthcoming. This is an issue that has to be dealt with by the community writ large. And Joe, I just respectfully disagree, and we certainly can have a sidebar conversation, but I think this involves the entire community to get rid of this notion that the ARB is some independent entity that can do whatever it damn well pleases. And I also want to come back to the standards that you've referenced, Stephanie, because what you've characterized as conditions are not conditions. The table you listed, 12C1, is subdivision plat information requirements. That is a list of information that was supposed to have been provided. The Planning Commission has the explicit authority under the town's ordinances to approve, disapprove, or approve with conditions. The information requirements are not conditions. And it's passing strange that the town planning director can say, well, we're recommending this condition, but any conditions proposed by affected parties, and believe me, Riverview is an affected party in interest because we're an adjacent party, or can't be considered, I think is extraordinarily flawed. So I hope when the Planning Commission comes to this issue again in the future, you will reevaluate that. But to look carefully at the provisions of the ordinance, look carefully at the provisions of the development agreement. We've got to get past this stuff, folks. We just absolutely need to. And I have a lot of respect for what the ARB does at the staff level. And they've done great work for the island as a whole. But they've dropped the ball with regard to the Cape and the timbers. They've dropped the ball with Lot 1. You didn't get any answer to the issue as to how was it that several acres was a land disturbance permit issued by the town? Was one issued by DHEC? If not, the town has the authority and obligation to enforce the impermissible clear cutting of trees. And if it's a violation of the development agreement, then the town has the authority and obligation and responsibility to enforce the violation of the development agreement. And that may mean mitigation. You can figure out what the remedies are, but it could also mean termination of the development agreement. My apologies, and for anybody who's watching my little rant here, but these are issues that have underpinned all the things that have arisen with regard to community concerns over the last 6 to 9 months. And we've got to do better, and we've got to solve these things. Thank you.
Thank you. Any other comments from the public at this time? Commissioner comments. Michael, we'll start with you.
No further comments from my side. Thank you.
Thank you, Michael. Joanne?
I would like to thank Mr. Belt for his comments. I having done planning and zoning for a dozen years in another community, I'm amazed at some of the circular arguments of it's part of the development agreement, but the ARB, it's like the inmates are running the asylum. No disrespect intended, but I can't understand why the town has an agreement. We respect it. I have no problem with the developers building on their lots. They have vested rights, and I have no problem with that. Go ahead and build. But by the same token, there are rules in there, and I don't understand why we grant you all the rights to do it, but the rules that were put down in that agreement have not been followed, And I don't understand why the town, and I'd like the town council, at some point, I know they're down to 3 people, to weigh in on why they haven't enforced that, you know, and I would love to hear, I'm sorry I'm handed an answer, because I would really like to hear how that happened, and maybe there's a good reason for it, but you haven't, there's been nothing that's shown. I'm also uncomfortable with approving things without knowing the regulation under which, I'm a rules person, to say, well, we don't know what rules, so we don't know how long this is gonna last. I'm uncomfortable with, I don't have a problem approving it, I have a problem approving it without understanding exactly what regulation applies. I think it behooves us to understand that. And I had one more question I forgot to ask, and maybe Stephanie can answer it. When was the last sewer capacity analysis done?
I can't answer that question right now.
Okay, answer it later.
Yeah,
Thank you.
I'll get with Mr. Taylor. And then you have to get with KIU, the utility, so they can provide
That's
that
fine.
information to us.
Madeline?
No comments.
Mr. Dowdy?
No comment.
Andy?
I have one question for Mr. Belt, if I could. Your comments with respect to the development agreement between the town and the partners, would that apply to equally to the development agreement between the town and the resort?
It would be my view, absolutely.
To the resort?
There is a separate development agreement with KIGR.
I'm asking for, and I will hopefully receive, a full transcript of your comments, because I think a lot of what you're asking for is for the town to do something. And I'm asking, in the case of the resort, are you asking for the resort to do something?
The resort does not have a development agreement with Kiowa Resort Associates.
Oh, so it's only the development agreement with the town that you're worried about? Or with the developer?
The town has 2 separate development agreements.
I understand that. That's why I'm asking about the second.
So the issues that have arisen come out of developments that are pertinent to the 2013 amended and restated agreement that is with Kiowa Resort Associates, because they're the ones that have developed or they've transferred interest with regard to the Timbers, the Cape, Lot 1, and the Beachwalker parcels. Those, there's a separate agreement with Kiowa Island Golf Resort, and for example, there is a separate cap. It's not a dwelling unit cap like it is under the Kiowa Partners development agreement, and it's a room cap actually. And so just as we've discussed over the last several months, the dwelling unit cap under the Kiowa Partners development agreement with the town, at some point in time there will have to be issues discussed or looked at with regard to the resort, to the extent that they build the new hotel, they developed East Village, because I think it's 1,180 or something like that total rooms. I don't know kind of where they are in that cap, but those are completely separate agreements, and all the issues that we've raised here today with regard to Beachwalker, Lot 1, are all pertain to the development agreement the town has with Kiowa Partners.
So I can I interrupt for a second, Mr. Chairman? I've got a conflict coming up.
Okay.
Can we call?
Can I just add one quick question, one quick thing that I just wanted to just make clear, just so I understand, to Ms. Hennessy's question. With regards to the preliminary plat approval, Kiowa Island Utility has to submit a letter stating that they can handle the capacity. When the island was master planned out, I think before it was over 7,000 units, down to 4,000. So I'm guessing when they put in the system, they put it in to be able to cover the master development of that scale. So I would probably venture to say that when we get the letter from them, they already submitted a letter saying that they can cover this capacity. So I think, I'm not sure.
Yeah, no, I saw that. It's just in the development agreement, it says that at least 3 times you're going to do it. I was just curious if it had been done.
Okay.
And I'm sorry, Mr. Capelli, did I answer your question? I want to make sure that I did.
You did, but not sufficiently, but that's all right. We'll talk
Have an
about
offline
Thanks,
conversation.
Mr.
Have an offline conversation. Buy him a beer.
Why don't, I will entertain a motion for adjournment. You'll make that motion?
I enthusiastically make a motion to adjourn.
Second.
And it's been seconded. All those in favor say aye. Aye. Opposed? Thank you.
Thank you.
See you, Larry.